Well, good afternoon. My name is Matt Parker. I'm a member of the firm of Marshall, Parker, and Weber. We are here today to present a webinar on how to prepare for the unexpected. And this is part 2 in our series. It is called The Legal Aspects of Preparing for the Unexpected. It's a series on how to deal with the unexpected death of a loved one. We're trying to go over some of the practical and legal as well as financial issues you can address to deal with this challenging time in someone's life when they lose a loved one, particularly in the case of these facts where we're outlining what happens when a spouse unexpectedly passes away. So I am here with my co-worker, Jody Lose, to co-present the materials today. And we're going to go over a fact pattern with you and then go over some practical legal issues that you may want to address now in anticipation of potentially and hopefully nothing will happen, but in the event something happens to a loved one, you are prepared for this tragedy. So, Jody, you and I are going to go over these materials together. And by the way, Jody's been with us for a long, long time, almost as long as I've been here. We won't say how many years that is, but she is one of the case managers at the firm and works on the various cases with me. So, Jody, we have James and Deborah. They're about our ages, and James has a son. I think this is from a first marriage, isn't it?
Right. Yes, I believe so.
Yeah.
His name is Michael, and he's 14 years old.
Yeah. And then they've got a child of this marriage. So James and Deborah have an 8-year-old daughter, Lily. So interesting facts here. We switched it up a little bit. So this is not a first marriage with simple facts with 2 kids. This is a second marriage, and you've got a son from a prior relationship. And these 2 have been married for 7 years. Okay. And the unfortunate facts in this case are that James, otherwise perfectly healthy, passed away suddenly of a heart attack. There was no indication of health issues. Deborah wasn't expecting this at all, so this was not a situation where he was battling cancer and long illness. This was a sudden death. And so Deborah's left to determine what she should do next. Her situation is rather challenging for a few reasons. Obviously, she's lost a spouse at a relatively young age, so we'll have to talk about how that affects her financially. And then she has this stepchild in her life as well as a minor child. She needs to find a way to support herself and these kids. And we obviously don't know what her husband's estate plan looks like. And keep in mind, we added that this is a second marriage, so there might be issues with the first wife going forward. So let's see if we can flush out some of the legal, and I'll touch on some financial issues as well as we go along. And the first item I'm going to talk about is one that probably was mentioned in the first presentation, but it's worth repeating because there's this immediate concern about how is Deborah going to provide for herself, let alone this child, with a husband who's now deceased and can no longer provide financial support. And the first thing that comes up with most attorneys as well as financial advisors is the use of life insurance. It's the classic way someone will recommend to protect yourself in the event of a loss of income. And it could be through disability. If the spouse becomes injured through a car accident or other injuries, and they're unable to provide for themselves. There are other types of insurance that can provide support during this time beyond just life insurance. There's disability insurance. So insurance is one way to help address the unexpected illness or tragedy in a family. So typically what I do is I review the financial information with the family. And Jody, when we do appointments with families, we send out what's called a client information questionnaire. Doesn't that have all of the information about the assets down on it? We usually gather as much information as we can about the family.
That's correct. We gather a lot of financial information to help us give options to the clients when they come in. And part of that is life insurance, whether it's a whole life, term policy, and I believe also mortgage insurance can be listed in there as well. So that's an important aspect that might actually help in this situation if there was a mortgage insurance policy, that it could help her to pay off some of the debt of the house, help her with her wage situation that we've been talking about.
Yeah, and we're an elder law firm, but these clients are much younger than some of our older clients. And mortgage would probably be logical in a case like this. They'd be paying on a 30-year mortgage, so that would be one of the types of insurance they might have at their disposal. And it's so inexpensive because it's term insurance. It's only going to last as long as your mortgage is around. So it's an inexpensive investment for you, and it's great if one spouse dies and there's insurance, mortgage paid off. Well, that's a major debt that Deborah doesn't have to deal with.
Absolutely.
Yeah. Now, when you talk about other types of insurance, the insurance agents often will mention whole life insurance. These are types of insurance policies that have a cash account or an investment account associated with it. These types of insurance policies can vary in terms of their benefits. But in general, what they're looking for when they sit down with you is they're trying to figure out, listen, if one of you died, how much money do we need to replace this lost income? So they'll try to factor over the life expectancy of one or more of you, accounting for inflation and the value of money over time, and so on. And so they'll figure out how much insurance you might need. In other cases, it's like a needs-based approach. What would the family need right now in terms of overall resources if one of you died? They would look at your debt, maybe the educational needs of your children, your retirement needs, and they try to come up with a plan to meet all of those needs if one of you had passed away. And some of these policies are really creative in is that you can adjust the amount of insurance over time. You can pay less in premiums, and then the amount of the death benefit will be reduced. And you can understand why this will be valuable, because as we get older, we need less insurance. So I certainly encourage my clients, if they don't have a financial advisor, do meet with one, do meet with an insurance agent and go over these issues, particularly if you have young kids, because it's one of the most valuable parts of your estate plan that will help address these concerns. And James, if he were to go out and acquire insurance, he'd have to think about not only his current child, Lily, with Deborah, but he's got to think about James. I mean, James has lost his dad, and he's not available to help pay child support. So we've got another issue in terms of dealing with Michael's loss in terms of his dad's ability to help support him. So the insurance discussion is going to draw in Michael as well to this discussion. So the insurance discussion is something that I would have right up front with Deborah. And the question will also come up, Jody, as to whether we should leave that insurance outright to Deborah, or should we use trusts? And we're going to mention some trusts in a while, because we're not quite sure what Deborah's future is going to be like. Who's she going to meet? I mean, she could meet another guy. It might not be the best relationship. If you leave all the money outright to Deborah, it's hers to take and mix with her next significant other. And so you may want to talk about some trusts with the attorney, and we'll go over those in a moment or two. Last item I want to go over on this slide, I just want to mention that a lot of our clients today have 401k plans or IRAs. There's typically a big requirement that you name your spouse as the primary beneficiary of these plans. And they're different plans than some of our older clients, Jody. We used to see a lot of clients with pension plans, and they would take either the maximum distribution or 50%, and the less they took, the less their spouse, or the more they took, the less their spouse would get. Yes. And they might have an insurance policy to make up for that difference. So a lot of our older clients had to deal with the pension rules. Today it's more 401ks.
That's right. Most people that come in, they do have the 401ks instead.
Yeah. And normally you have to name your surviving spouse, and if this is what Deborah's going to be living on, a 401k, there are going to be some penalties if she has to withdraw from this plan prior to the age of 59. So you've got to be concerned about penalties if you're planning on living on a 401k. It's really intended for retirement purposes. So when you look at your financial picture, do you have enough money to pay for the day-to-day expenses without having to dip into an account like this? All right. Other than the financial matters, let's move on to another area of concern, and actually, I would say, real benefit to surviving spouses and minors. There's a loss of income, obviously, and one of the ways you can replace the income is to look to the Social Security system. If we paid into the Social Security system for the required number of quarters, as they call it, our surviving spouse or our surviving minor children are entitled to what are called survivor's benefits. It is a monthly payment from Social Security, and it is based on what we paid into the system during our work years. So let's presume for this discussion that the deceased has in fact paid in to the system. James, he has paid enough quarters. His spouse, surviving spouse, is allowed to draw on his full retirement benefit. Now, she doesn't get the same amount he would have received had he gotten to retirement, but she's entitled to a percentage. Basically, a widow between the ages of 50 through 59 is entitled to 71.5%. If she's younger than age 50, and I think in this case she's 47, she's entitled to 75% of what would have been his full retirement benefit. So if you've got a $2,000 full retirement benefit, she's going to be entitled to 75% of that every month until she reaches full retirement age. And the children, if they're under 18, in this case, both of them are, they get 75% of his benefit as well. So that's a sizable amount of money that's going to come into this family to help pay for the bills and expenses of raising those kids. So I certainly encourage anyone who knows somebody who's lost a loved one to look into the survivor's benefits. You actually have to call the Social Security office. There are 1-800 numbers where you would go and contact them to make the arrangements. It's not an automatic system. You do have to call them and make those arrangements to get those benefits. But that's going to help out a lot in this case. Beyond Social Security, we're going to talk a little bit about trusts. It's a big part of the attorney's toolbox to help, particularly in these second marriages. We want to make sure that when clients come to us and they say, listen, I've got this kid from the first marriage, Michael, and I've got this new wife. I'm married to her for 7 years. I want to make sure the wife is provided for, but I also want to make sure that that child from my first marriage is also provided for. I don't want to leave everything to my new wife. She may or may not have a close relationship with her stepchild, so I want to make sure he's provided for as well. So how do they go about that? Usually we'll look at all of their assets, as Jody mentioned, and look at different assets that we may be able to leave to the surviving spouse, and certain assets we may leave to this child or the children. We may want to include Louie in this. So we can sort of leave certain assets, sometimes the house to the surviving spouse, and maybe life insurance to the kids. So that's one of the reasons we ask about all of the assets and try to figure out, if we've got a nice 401k, does it make sense to leave that to Deborah and maybe some life insurance to a child in trust? And I'd ask a lot of questions about who brought the assets to the marriage. How was the house paid for? It's often a big one. Sometimes it's joint funds. Sometimes they each sell their house and they buy a new one and they put both names on it. And Jody, if they do that, normally the house is titled jointly with the right of survivorship. Is that logical? If they both buy the house and put their names on as husband and a wife?
Yes.
Yeah.
There's a lot of times when people sell, like you said, their individual homes from a prior marriage and then bring those proceeds in. And as a husband and wife, it would be jointly owned property as tenants by the entireties. Yeah.
So if one dies, it automatically goes to the other.
That's correct.
That's right. So it doesn't really matter what we put in the will. When you put both names on property like that, when they're married, the survivor will take title to the home. So that's one of the considerations you have when putting a spouse's name on. If you get married and the wife says, hey, put my name on the house, it's going to be jointly owned, and if you have a falling out with that spouse, she doesn't want to take her name back off, you're out of luck.
That's right.
You are stuck with that arrangement. So let's say James bought the house with his own money. Deborah had sold her house and put her money in her investment account. But James now wants to leave the house to Deborah, but he wants her to live there only so long as she wants to live in that house. If she doesn't want to, he'd like to have the house sold and some of the money go to Deborah, but also some of the money to go to his son, Michael, and maybe even Louis.
Yes.
So what is a life estate? What if he said, okay, Deborah, you get to live there for the rest of your lifetime, but this other thing happens if you don't want to live there. How does the life estate work?
Well, there are a couple different kinds of life estates. And in this particular case, since James would have had the property coming into the marriage and it would have only been in his name, I believe in our scenario here that we're talking about, he would be granting his new wife a life estate interest in this property. The other scenario would be if the person owned the property, they would be retaining a life estate interest. So it's a little different situation in this case since Deborah's name was not originally on the deed.
Right, so he gives her an interest. He says, when I die, the property's in my name, I give you, Deborah, an interest in this property, and your interest is that you can live there for the rest of your life. The moment you choose not to live there, you give up your life estate. Property has then become part of my estate. It gets sold, and you get a percentage of the value, maybe 50%, whatever he wants to give her. And the other monies go to the kids. And they might actually go into trust for those minors because we don't want to give money directly to those kids. But that's one way to manage a property where you don't want to just give total title to the surviving spouse. Other monies that James might have, he might leave in a spousal trust for Deborah. The spousal trust is a way to hold money for the benefit of Deborah. But if she doesn't need or use all that money, then when she dies, what's left in the trust goes to the children. So it's a way to benefit, your spouse at the same time, your kids, and in this case, the child from the first marriage. Usually there's a trustee managing the money for Deborah, and they'll distribute those funds to her as she might need them for her health, maintenance, and support, whatever it is she might need. The question is, who would you choose as trustee? That's often a challenging discussion, isn't it, Jody?
Yes, it is.
Do we have a trusted family member who can manage this money for Deborah? Who do we want to name? Sometimes you name a financial institution. Banks have trust departments, don't they?
Right. Yes, they do.
Yeah.
We use those a lot also.
Yeah. So we may name somebody from the outside of the family to manage this trust fund for Deborah.
And especially, I think, since these kids, they're both minors.
Yeah.
A lot of times if you have older children, you can name, mix some of those older children from each of the prior marriages. But in this case, they're both young. So you've got to kind of look outside of that to other family members, maybe, siblings, parents, or professionals.
And these spousal trusts are really popular in second marriages because they've been through the divorce. They understand, listen, I don't know if the marriage is going to work out. I don't want to leave everything in my will to the surviving spouse. But if I leave everything in trust for her, I know that if she goes off and gets married to somebody else, she doesn't have title to this money. She can't just take it and consume it and use it at her discretion. It's in trust. She has to go to a trustee. You can put all sorts of terms in these trusts. For example, they may say, you have to use your own money first, Deborah. So if Deborah's independently wealthy or she marries a really rich person, then this trust fund doesn't get consumed by her. Yeah, there's a better chance it will remain there for Michael and Lily. So those are some of the ideas that you can put in place with spousal trusts. You don't have to leave everything to your surviving spouse. You can set up a trust plan for them, particularly in the second marriage. One of the other documents we talk to clients about, particularly in second marriages, are these nuptial agreements. You've probably heard of them as prenuptial or postnuptial agreements. Pre meaning you sign it before you're married, post after the marriage. Unfortunately, in our country, we still have a 50% divorce rate. So a lot of people, particularly as they get older and they get into the second marriages and they have resources, they say, listen, if this doesn't work out, I want an agreement where you take what you brought to the marriage if it dissolves, and I'll take what I brought to the marriage if it dissolves. We won't take each other's assets. We won't claim against each other's assets. We won't ask for spousal support. We won't ask for alimony. It's a way to arrange the financial agreement to dissolve the marriage. It has no effect on child support, but it does have the effect on what you can claim against your spouse if you divorce. Now, you can totally alter this entire arrangement, and we've seen this particularly with our older clients. After a while, they just pool all their money. They just put it into a big joint bank account or joint investment accounts, or they put each other's names on the pieces of real estate, and they totally undermine the nuptial agreement. The nuptial agreement presumes you're going to keep your assets separate from your spouse's assets, and maybe you'll have like a small checking account that's joint, but everything else stays separate. As you get older, maybe the marriage is good and you don't feel the need for these agreements. And obviously you can change the agreements through the will or any beneficiary designations. If you put your spouse on as a beneficiary of an investment account or an annuity, an IRA, or you leave money to your spouse in your will, that will also undermine the nuptial agreement. But they work fine if you follow the rules, and they tend to work hand in hand with an estate plan. We will draft a nuptial agreement for our clients at the same time we do the wills. So it helps restrict what you can do when one person dies. You can't claim against their estate. Think of the Brady Bunch situation. If Mike Brady dies and he leaves everything to his boys, what was Mike's name? I forgot. It was Sally, I forget, but Mike, in the Brady Bunch scenario, his wife couldn't claim against his estate in the event they had a nuptial agreement. He could leave everything to his 3 boys. Probably wouldn't happen in this case, but it could. They could have a real falling out, and you wouldn't want the estate plan undermined, and this document will help with that. So you want to put a prenuptial agreement together or a postnuptial agreement when you're doing your estate plan to ensure that your wishes will be followed. Keep in mind, you have to disclose everything up front. You can't hide assets, and you typically have separate lawyers when having these agreements signed to make sure they're binding. Moving on to the other item that we mentioned already, and it's the dealing with the minors. We got 2 minor kids in this case. How do we deal with them in our estate plan? The first topic that comes to mind is the custody of minors. I would presume that there's a custody order for Michael. I mean, this can't be something that in a divorce situation, James could affect through his estate plan. He could say, I want my current wife, Deborah, to be the custodian for Michael, but that's not going to trump the order issued by the court with regard to custody of Michael. And unfortunately, no matter how close Deborah is to Michael, I think Marcy is going to be the person who will take custody of Michael and decide when and how Deborah, or even if she can have visitation with him. There's not much she can do about it. But with Lily, you can name a guardian for Lily. So if James is out of the picture, obviously the mother takes over, but if both of them are gone, you can actually put guardians in your estate plan. Typically, they show up in your will. They say, in the event my wife and I are both deceased, this person will be the guardian for my child and will make decisions about their finances and all their personal needs. There's also something called the standby guardian, Jody, and that's where they're not dead, but they're incapacitated. They're both in a car accident, and they can sign a document that says, hey, this person will be the guardian while I'm not able to care for my children.
That's right. And in a lot of cases like this is where you would end up pulling in family members. Somebody that is from, if it's for Lily, Deborah's probably going to be looking at, maybe if she has some siblings that she can name, if both of them are deceased, or, we're talking about standby for incapacity. But that would be really helpful to have that in place.
Yeah. And the last item for the kids, we talked about trusts. It's a way to manage assets for somebody. And you'd want to have minors' trusts in the documents for both James and Deborah. You'd say, both of them are gone. Here's what happens. The money goes in trust for these kids until the age of, you pick it, 25, 30. Money's used to pay for health, education, maintenance, and support. You can actually have money distributed at certain ages, 10% every, this year, when they reach 25, 30% when they reach 30. and so on. You can have a family member manage the trust account, or you can have a financial institution. And you can always change these. Jody and I were talking earlier that one of our clients from years ago, he didn't want his daughter spending any money on dog shows. I distinctly remember it. He hated the fact that his ex-wife was spending all his money on dog shows, so he put in there, if I die and everything goes to my daughter, she can't spend a dime on the dog shows. He was really ticked off about that. So you can put all sorts of things in these documents for your kids that are unique. So if you're gone, you're probably going to have a will that says where all of your money and your assets goes, but I really recommend something called personal instructions for effects. You're going to have stuff in your house that might actually be a lot more valuable and interesting to people than your monies are or the real estate. I'm not talking about the garden variety stuff that we all have, like TVs and couches, but these are items that you acquired that people tend to identify with you. It may be a classic car, wood carvings that you made, your hobby cameras, your photos, the jewelry that's been handed down from generation to generation. Those are the things that people really fight about after somebody dies. And in this case, there may be fishing rods that James had, and he always went fishing with Michael, and those fishing rods he would have wanted to go to Michael. Well, in his will, it probably says everything goes to Deborah. Well, if you want to avoid that, put down basically a list of instructions that says, when I die, I want my fishing rods to go to Michael. And you got to sign and date it, keep it with your will, give a copy to your lawyer, and make sure that hopefully, those instructions will be followed. Now, if you have a good executor, somebody you're trusting, they will typically follow your wishes. The alternative is you leave everything to your surviving spouse. She has a falling out with Marcy, doesn't give the fishing rods to Michael, gets remarried, and those fishing rods go, who knows, to the next family. And there's lots of hard feelings. My family had Civil War letters. There was an old ancestor of my father's, and we had Civil War letters handed down from generation to generation, and the same thing happened. My grandparents didn't put anything in writing. They ended up going to a non-Parker, and trust me, there were hard feelings about those letters. Still to this day, my father won't let it go. All right, last item, estate administration. Just a comment about this, when somebody dies and they own assets just in their name, typically we have to open an estate for that person. We can't pass ownership to the surviving spouse without opening an estate. Or unless as Jody mentioned, you already put her name on the asset. But otherwise, we're going to have to open an estate and then transfer ownership to the beneficiaries in the will. It could be a trust in your will or other beneficiaries, but nevertheless, we have to go through something called probate. It's not the end of the world. People are all concerned about probate. It happens all the time. But it's the court-monitored process by which we take the will to the courthouse, appoint an executor, and then transfer ownership of the assets to the beneficiaries. So typically happens when both spouses are deceased, particularly in a first marriage, but in this case, you might have had probate for James. So if you see an asset that's just in one spouse's name, like a piece of real estate or an investment account, and your name is not on that, you'll probably anticipate that if your spouse dies, you'll have to go down and open an estate. And an attorney typically works with you on the estate. Lots of forms to be filed. A tax return has to be filed, so there's a fair amount of work probating. And sometimes our clients just miss assets, don't they, Jody? They forget that there's this stock in the husband's name.
Yes.
And they didn't put the wife's name on. And
yes.
We got to go probate. And it's frustrating for some. In this case, it may have been intentional. James may have left an estate with assets in his name, and so there had to be an estate opened, and it's not the end of the world. And that brings us to the end of this presentation. The next part is about funeral and burial considerations. That's on October 12th. So if you're going to follow us to the end, keep that date in mind. You can always listen to these online. So do recommend it if you've enjoyed today's presentation. On behalf of Jody Lose, thank you very much for listening.